Namaste friends, welcome back to Kaydanivato. In today's video, we will explore the BNSS Chapter 19, Trial Before a Court of Session. This chapter explains us how the trial commenced before Sessions Court and how the trial conclude before the Sessions Court. So let's break it down and make it simple. This chapter covers the section 248 to 260. Section 248, trial to be conducted by the public prosecutor. All trials before a court of session must be conducted by a public prosecutor. That's why the prosecution in sessions trial is to be conducted by the public prosecutor. Section 249, opening case for prosecution. When the accused is brought before the sessions court, for example, after commitment under the section 232, the prosecutor must open the prosecution case by describing the charge and stating what evidence will be relied on to prove guilt. Section 250, discharge. The accused may apply for discharge within 60 days from the commitment if after considering the record and hearing submission, the judge finds no sufficient ground to proceed, the judge shall discharge the accused and record the reason. Section 251, framing of charge. If the judge thinks there is a ground to presume the accused committed an offence, the judge will either frame a charge and transfer the case to a magistrate if not exclusively triable by sessions, or B, if exclusively triable by sessions court, frame the charge in writing within the prescribed time, read and explain it to the accused and ask for his plea. Section 252, conviction on plea of guilty. If the accused pleads guilty, the judge shall record the plea and may, at his discretion, convict the accused on that plea. Section 253, date for prosecution evidence. If the accused does not plead guilty or claims to be tried, the judge shall fix a date for prosecution evidence and may issue a process to compel witnesses or production of documents. Section 254, evidence for prosecution. On the fixed date, the judge takes the prosecution's evidence. The statute expressly allows recording evidence including deposition of public servants by audio, video, electronic means and give the judge flexibility about timing of cross-examination or recalling witnesses. Section 255, acquittal. If after a prosecution evidence and hearing, the judge finds there is no evidence that the accused committed the offence, the judge shall record an order of acquittal. Section 256, entering upon defence. If the accused is not acquitted under the section 255, he shall be called upon to enter his defence and produce any evidence in support of it. Section 257, arguments. After defence evidence, if any, the prosecutor shall sum up the prosecution case and the accused or his advocate has the right to reply. If a legal point is raised, the prosecution may, within the judge's permission, make submission on it. Section 258, judgment of acquittal or conviction. After hearing arguments and any points of law, the judge must give a judgment as soon as possible, normally within the 30 days from the completion of arguments, extendable to 45 days for record's reason. If convicted, the judge will hear the accused on sentence and then pass the sentence unless other provisions apply. Section 259, previous conviction. If a previous conviction is alleged per the charge rules and the accused does not admit it, The judge, after convicting under section 252 or 258, may take evidence on the previous conviction and record a finding. The earlier conviction must not be read or relied upon until the accused is convicted on the current charge. Section 260. Procedure in cases instituted under the subsection 2 of the section 222. When the Court of Session take cognizance under that special provision, the court shall try the case in the manner applicable to warrant cases instituted otherwise on a police report before a magistrate. The accused, unless the court direct otherwise, will normally be examined as a prosecution witnesses. Trial under this section may be held in camera of either party so desires. The section also contains the power to award limited compensation recoverable as a fine if the court finds there was no reasonable cause for the accusation. So friends, this was the chapter 19 of the BNSS which we discuss right now. If you find this breakdown useful, then like, share and subscribe this channel. We will meet soon in next video with chapter 20. Till then, bye. Take care. Jai Hind. Stay connected with Kaydanivato. Stay informed. Stay updated.